Good morning, everyone, and thank you for attending this roundtable on new governance in public procurement. We'll be talking about public administration and procurement, of course. We heard from Professor Ferlio and Molina in the earlier session. This is a continuation, but with a slightly wider panorama. I think the challenge we all face is that the concept of electronic public procurement cannot be limited just to electronic resources and procedures and organizational matters, but rather it's something we must see as something much more extensive as a means to achieving the organizational changes and procedural changes that are necessary and imply with the principles of transparency, free competition, non-discrimination, and the effective use of public funds by innovating in the acquisition of goods and services. And it's absolutely essential to have governance for these more extensive roles, not just the mere modernization of electronic resources in the current structures. So this roundtable is essential to be able to talk about a topic such as governance. And we'll be talking about the policies in place to encourage the principles of efficacy, transparency, and responsibility. In other words, switching from current system to good administration in the electronic sector. So this panel will be thinking about good administration for procurement, and it's not just a manifesto or the reading of the CVs of the people. We'll be hearing from experts in the field and excellent speakers. But I want to make this more dynamic. Instead of having monologues from each of the three speakers, one after the other, we're going to have a dialogue through a series of questions based on a script that we've agreed. So in this sense, one of the challenges posing electronic procurement in Spain from the perspective of governance is the professionalization of public procurement contracts. Subsequent panels will be discussing this again from the perspective of some of the players in these procurement policies and processes. The first question I have for the speakers is, do you think that at the different levels of administration in Spain, is there anything that you think is missing? Something that might prevent us from avoiding the bad practices in public administration? And what organization and what procurement procedures do you think need to be amended in order to prevent these negative dynamics? Yeah, so we'll start with you, Elena, and then we'll go on to the others. Well, good morning, everyone. This is a very specific question. Before I answer it, I'd like to point out that the special resource for public procurement, the courts, can be seen as a governance instrument. And from that perspective, this is how we would answer the challenges posed. So your question is about the issue of professionalization and audit functions in the public administration. Well, from a practical perspective, with the special appeal, we've seen one phenomenon. As a result of the general legal philosophy that's been established and precedents, it must be remembered that the lack of legal certainty may have given rise to these very technical and complex rules, which are difficult to understand. And because of structural deficiencies, the administrative dispute courts are unable to respond quickly, and they simply applied historic precedent. And that lack of legal certainty and the legal principles have sometimes put the technical experts, who are the people responsible for applying the procurement law, in very difficult situations, very complex positions, because they have politicians or non-technical personnel pressuring them. And if you don't have certainty about the rule, it's difficult to reach a valid conclusion. So in procurement areas, this law has been useful. It's given us a series of inefficient practices. I'm not going to say corrupt or incorrect practices, but the number of inefficient practices that have existed in the procurement process in Madrid have managed to disappear gradually. Let me give you a very simple example. In the procurement specifications for the medical service in the region, which appeared 6 years ago, you've got a scale of 0 to 6 points for whether it was applicable or not. That solution is no longer applied. The But for technical personnel, we thank you for having adopted a series of resolutions that have allowed me to go to the politician and say, this is something that you cannot do. And as Professor Jimeno Feliu said earlier, this is something we need to do. Keep the politicians away from the technical issues. That's not their role. They have to take the major decisions and leave the professionals, leave the technicals to do those. And the special appeal has made this possible. It's given the court certain philosophical arguments and legal certainty on aspects that are suitable for the technicals who need to apply them in practice. Will we need to have a scale of 0 to 5 in the new law? Yes, we can probably still do that, but it's been very useful. As a tool for greater governance, the special appeal is very useful, but if it needs to be improved, yes, it does. And the organisers have asked that there are cards available from the hostesses around the rooms for you to write your questions and submit them to the panel for discussion later. I was saying that the text distributed as the potential new law for the Public Sector Act, or whatever name it gets at the end of the day, what cannot be used as a subterfuge. We have to respect the principles of legality, and we haven't yet been able to do so. We've talked about efficiency, but we also have to talk about audacity and ambition with the law. The speakers and the people involved in public procurement are always talking about technical inspections prior to the event, and we'll perhaps argue about this later, but we get the prior inspections and the prior audits. Blah, 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 blah. I'm talking on behalf of the state auditors and inspection boards. But prior audits and inspections can be seen as a checklist, and we just tick off the boxes. I want to talk about the systems, the management systems in place, and the mitigation of risk in public procurement. I think those aspects are much more novel. We have to look for automated systems that can prevent the risks and not be merely reactive. The 2010 reform was a major step, but we have to move to the preemptive stage. We can talk about this later. Good morning. Talking about professionalization, which is not a new thing, but something that has evolved greatly from the initial concept that we had, and also bearing in mind the very powerful participation of the different institutions of an international nature that have analysed this problem, particularly the OECD and the European Commission. I think nowadays the fundamental issue within professionalization focuses on striving to achieve both a preventive function and also a corrective function, and that avoids the problems that everyone sees in public procurement on a daily basis. And one of these problems focuses on an aspect such as the training of the people involved, not just in the legal aspects, which is obviously important, but also in other aspects, such as the knowledge of markets, the economics training, budget training, and other types of qualifications. It's interesting to share some thoughts that may be made in the OECD on the creation of multidisciplinary teams that are capable of bringing together people with all the specific knowledge that is needed, and also the thoughts that have been reached, or the conclusions that have been reached by the public administration, which are not the only parties involved in public procurement contract processing, but also from the economic players themselves. And one of these thoughts, I think, is particularly relevant as the starting point for this discussion. If we know, because lots of people have said it or written about it, that public procurement is a major part of the EU economy and the Spanish economy with very considerable percentages, it's very striking that, to a large extent, there should not be, from both the training perspective and from the professional perspective later on, there should not be any awareness raising about the importance of this sector, of capital importance in the developed economies. That's why I feel that what we should be doing is thinking on a wider scale. That because of the different problems that arise every day in the procurement sector, some of them very serious and appearing on the front pages of the newspapers, we can see that there's something missing. What's missing is an element of specialization and better design of the teams involved, process facilitation, and the possibility of accessing more information by tenderers and so on. And this requires a systematic approach by a whole range of players when assessing the different solutions that can be offered. It's true that legislators, in most cases, adopt a position that is closely focused on purely legal matters. Our procurement legislation is aimed at the transposition of EU directive, and they probably don't go down as deeply into such aspects as we would like. These might be due to organizational nuances, which are more specific, and they shouldn't perhaps be included in legislative text, but I miss, at least to some extent, the idea or the attempt to deal with these ideas, which are no longer novel, but are commonplace nowadays, and they can help us to improve public procurement in all senses of the word. Thank you very much. And now, continuing on with some of these topics that have arisen, one of the key issues that we say with regard to new governance in public procurement is transparency. Both the central government in Spain and the European Commission have focused their attention into strengthening the obligations with regard to public notice for procurement. But there are still some lacunae, and the previous speakers have already suggested that there's a failure to comply with some of these obligations. So what specific changes do you think need to be introduced to ensure that transparency successfully achieves the goals of preventing corruption and also, no less importantly, encourages participation? I'm going to continue talking about my area, at least, the specific remit of the court I represent. I want to speak about the special appeals, and in particular with regard to the report from January 24th, 2014, from 2017, January 24th this year, from the Commission about the use of the special appeal in procurement throughout the EU. And they highlight a series of aspects, but they speak about transparency still as in the wake of this report, which is the result of a series of surveys. They say that 85.9% of interviewees think that as a result of the introduction of the special appeal in the different member states, public procurement is now more transparent. So this is the first measure in which we've already achieved it. Well, we have to delve more deeply into this, and I think that this special appeal is able to achieve these higher levels of transparency. Why not do what the next Commission report suggests about the progress of the different member states from February 2017. That report says that there is still room to implement additional checks. There's still room for additional checks. So, in line with what the legislation is doing, we could delve further into the objective scope of the law, as in the draft bill, and resolve the technical and legal problems that may arise. But we feel that if a contract emerges and the process is one way and ends up very differently through amendments at the end of the day, and this can at least lead to a lack of efficiency at the very least. So that would be a very good measure to introduce. And as the directives are beginning to be regulated, it's possible to consider the application of the direct effect of these. The resolution of the contractual effectiveness is also possible through the normal courts. But I think we need to provide additional resources. And there are a lot of the amendments, and nearly all of them, in fact, are going in that area. The political parties are suggesting that the contracts should be opened up. There are some cases of rescuing subsidies and salvaging subsidies from other courses, other contracts, and due to inefficient practices. And the People's Party has suggested that the objective scope of the appeal should be extended to regular passenger transport, which were under a different regulation heretofore. So with regard to the special appeal, I think we're moving in the right direction. But I don't want to take this opportunity to share with you a thought that I've had in the back of my mind for some time, that we're talking about checks, about transparency, about public notice. This is all well and good, but Spain is a very pendular country. We go from black to white and back again very, very quickly. If we add checks and inspections and we hinder public procurement too much, we could end up with the opposite effect of what we want. And there are some practices, and I can give you an example, as I said before. We end up swinging back too far. We have to be careful with that. The law of transparency and good governance requires the publication in Article 8 of the contracts. Okay, all well and good, but many of the bodies, not as a result of the entry into force of the directives, but as a consequence rather of the social and political pressure that we have, the mistrust and the fear of corruption and so on, that in many cases the different contracting bodies are required to publish all of their resolutions in real time. And what happens? That when they accept tenderers as qualified to participate, and there's no measure for appeal against that, or when the ranking of the tenderers is published and classified, then this can be appealed now, and the process is suspended. So while the reports are considered in the case file and legal proceedings are away, you've stopped the whole contracting procedure for at least a week, and that's considerably fast. But if we keep doing that every time something happens or is published, then we could have a tremendous problem. That's just one example. But there are other things. Be careful about taking these checks to the point where they cause hypertrophy in the public administration. This is something perhaps that could be the subject of debate later on. Yes, absolutely, Elena. I wasn't going to mention this. At the CNMC, we are not so happy with the current legislation, and it's a matter of transparency. As you know, the consolidated text in its Article 8A says this, but this is the scenario from which we start, and it's the minimum standards. And I'm ashamed that we're only complying with 8.1a. But our thesis is the opposite. Transparency International and Madrid City Council said the opposite. That's the proper thesis. We can have external observers monitoring the 3 or 4 steps. In the procurement process, there are only 4 steps. Is it an obstacle to have these external observers? Article 18 and other constitutional rights might be affected. But we need to start looking at this from the opposite perspective. And the only way we'll be able to achieve it is if we make people believe that we can achieve it. We can do more than what the law says. We establish the law as the maximum rather than the minimum. We have an opportunity opportunity. This is a great innovation laboratory, and we're not taking advantage of it. This is our time, our chance to have state-level legislation. And from the Monopoly Commission is what we're trying to do. The law is only the minimum standard. We need to go further than that. So let's see if we are ambitious enough to move forward. I think that transparency is often one of the most important aspects in the whole of the development of the process for selecting contractors. If it's seen, as Carlos has just said, we have to cover all aspects of the process. And if this is considered right from the start, the contractor selection process, then this transparency will also occur at the later phases of the preparation of the contract, the award, and the enforcement and termination of the contract. There might still be serious problems related to the lack of transparency. Right at the start, through the phenomena that we're all familiar with, that resorting to appeals in legislative law, that the legislation is trying to avoid it, but the current legislation has not avoided it, has not succeeded in avoiding it in many cases. And in the later stages of the process, through issues that have been cited here today, such as the definition of the criteria for the award of the contract, at the moment of its drafting, and also in the application of the different criteria for its award, which may make it more or less selective, and the problems that may arise with regard to procurement issues in the special appeal courts, because all of the administrative courts have had to repeatedly give solutions to this question of access to case file documentation. It's true that, as has been mentioned, our practical experience shows that there is a problem that we could call almost as a cultural issue, a question of resistance to making that transparency something effective and efficient, often alleging professional and competitive issues of the tenderers involved. What can I say about the enforcement of contracts with the content problems that are generated by amendments, in which we have a fundamental problem that's been often cited by the European Commission, that we do things backwards from what they define. They want a preparatory stage of the contract, some time spent thinking about the contract for a long time, very thorough analysis, full of ideas and meditation, with reports and to's and fro's, followed by the simple, speedy phase of execution of the contract without complications. And in Spain, this is quite the opposite. The preparation phase is usually quite short, where it's done as quick as possible. The execution is done as quickly as possible too, and then the problems during enforcement arise, and that's when the amendments arise. And the culture is that I win the tender, and then we'll talk about what I actually have to do. And these obviously will be affecting the enforcement of the contract, and even after the termination of the contracts themselves, as has been mentioned before, I agree with what's been said. There is a possibility that these can be adjusted through the regulatory techniques. But it's a necessary change required in the mindset of the economic operators and of the sector, the players in the public administration when drafting the contracts. This change of mindset is probably the biggest change that's needed. Not so much legislative measures, which may also be required, of course, but it's more a change in mindset and the way that public administration looks on procurement contracts as an essential element of the Spanish and community economy. Carlos, you got anything to add in that respect? You're talking about amended contracts, and in that regard, I want to send a very clear message. We have to look at the facts and not weeks. And I heard Professor Jiménez Feliu before, and he said we're talking about the current late legislation. But with regard to amendments, it was 5 or 6 years ago that was considered subject to revision. And this is the path. And with the new law, we're not going to change very much. The bill is generating a lot of frustration at the moment, for many different reasons. Juan Manuel Contreras is here too, from the and Antonio Maudis, who is speaking later. And the question is whether we have a proper white paper on the roles of the contractors. And again, we've got 400 pages of great detail explaining. Well, I won't describe it. We have to move to facts, and as Ximena Feliu said about the measurements, we have to be able to advance down that road. We certainly want a law of transparency. I think the people who are in favour of transparency are true heroes of the process. I'm sorry, this question doesn't have any simple answer. There isn't any real legal obstacle, but we're not seeing it. At least we don't see it.
I feel tempted to open a discussion about this technical legislation technique difficulties, but we don't have time for this. Directive 24 from 2013 devotes a specific title to governance, but it focuses its proposal on controlling the rules of public procurement, but it also includes some requirements in terms of policies and strategies. It focuses in the supervisory function and bodies in charge of it. Beyond the function assigned to the committee for this purpose, my question would be, what else is there to be done so that supervision and control are really effective? Based on what I said before, supervision and control are really nice words, but they have to be balanced. They cannot make the system to become hypertrophic. We have the mechanisms. What we need to do is implementing them. As Miguel said before, now we have to change our focus. And in my opinion, focus has to be on drafting contracts, on drafting good reports, good economic studies, which usually do not exist. This would make this work much easier. And then, perhaps we should rethink the bodies or the functions we have, because external control bodies who do an excellent work do the work after the fact, and what they do is making managers feel embarrassed, but they're not effective. So perhaps creating a body similar to the one in Italy, which is one of the proposals of one of the parliamentary groups, an independent authority for supervision and control. It's true that this proposal mixes different notions. It has executive powers, also coordination, regulation, reporting, and review through appeal. But perhaps it would be a good idea to have this kind of body. I'm going to say something which might not be really nice to hear. We must not be afraid of having the participation of companies, the public sector. And once again, coming back to my idea, an important part of the supervision and control is undertaken by tenders. Supervision and control by other legal operators, once they're allowed to do, this is something really important. It cannot be taken for granted. They're not part of the system, but it's important. And then, in terms of more general supervision, such as an independent authority, of course, they need the means and independence. This is paramount. We should not replicate what we already have. Perhaps we should rethink it and implement a radical change of our system. I think the key is I'm going to be quite critical. Supervision, control, and accountability. These things haven't worked so far. The system hasn't worked because it's a system based on names which check, but this doesn't mean that the final contract is efficient. We're not studying the economic efficiency as a prevalent factor, and then accountability. We need to change the system of accountability of public servants. This has to change, and not as we did with former public companies. These kind of things have repercussions. With regards to supervision, I'm highly critical of the system developing Articles 140 and following. Many of you are familiar with this. This system is based on agreement by the Council of Ministers in 2008 and other pieces of legislation which were approved later. I think we can introduce ISO rules, and a risk analysis should be included in this bill. We need to identify risks when drafting contracts. We're all familiar with these risks. Why don't we do a map of risks? We add this to the bill to measure criticality in all aspects. We must not depend on the good disposition of people doing this. This system has to be automatic. This has to be a system of measuring risks and preventing risks. Reacting is not a good thing if it happens 5 years later. I fully agree with what has been said regarding both aspects. What Carlos has said is very important, and what Elena has said about legal control applied by tribunals, by courts. I'd like to add something. Perhaps the most proper way of having a genuine control of public procurement is based on internal control applied by the entities themselves, the contracting entities, and within these entities, by the bodies or individuals taking part in it. And I'll explain myself. First of all, within public procurement in a country, we have a specific body, an advisory body, and in certain cases it has more important powers because take decisions. This is the procurement committee. All the aspects regarding control are also related to accountability and professionalization. And because of this, I would like to say that all procurement committees for every existing contract in Spain right now have all the necessary elements to take decisions on this contract in all the aspects the contract has. And based on my experience, this is not the case. Unfortunately, in some aspects, such as Carlos has said, risk management in the contract itself, it's not studied at all in most contracts. So this is one topic. In the procedure itself, procurement committees, thanks to proper preparation, can apply a sort of control function, which in the end of the day, it's going to be that thing, a control. If they carry out a comprehensive work and check for errors, the quality of contracts will improve. With regards to the economic side of the contract, This would also have positive effects, since in the procurement committee we would have an individual with, who's an expert in economy. We've seen very often that people say, well, I checked online and I looked for 3 companies within the industry. This is not right. We need to have a person who's really familiar with the area. And this means an internal control of the procurement itself. Control after procurement is cold and most surely very independent. But due to the high volume of procurement in Spain, it's impossible to have a body in charge of controlling procurement. We can make studies and reach useful results, but in my opinion, we could focus in the internal control. And we have to define what people take part in the procedure of choosing the contractor, what people take the decision. And as Elena said before, the independence of people taking part in this kind of procedures is paramount. So I think this is the best way to act, to have an external legal control to improve controlling procurement. I think Carlos does not agree. Yes, I agree, I just wanted to elaborate. Usually, when managing risk, there are 3 phases. The second is internal control and third is internal audit. But the first one is preventive control. In our scope, the legislation we're dealing with, there are some details which I'm going to mention. There are people who apply permanent control. There's the legal report, we cannot read it, we cannot see it, because Law 39 has said that we cannot see intermediate instruments. That's what the legislation says. We're not going to see the opinion of controllers, and this has a lot to do with accountability. I think it would be interesting to see whether the legal report is brilliant and has considerations with regards to the procedure used, if the procedure is certain or not, the opinions. This is what we expect to see in a legal report, not just corrections of words, routinary corrections. I come from the legal experts in the army. Miguel, do you want to say anything about this? This is not an answer. What Carlos said has happened in a relevant number of cases, and in many administrations, reports cover just 3 lines. I think this also depends on the professionalism of every person, and also depends on the contract. We cannot deal with every contract in the same way. In general terms, we can say that the participation of a legal expert in any area of the public sector is an element for improving contracts, but it also can prevent, when drafting the report and afterwards, it can prevent bad constructions, bad applications of the contract, a bad development of the procedure, or an erroneous application or against the law of what has been stated in case law, legislation, etc. I agree with Carlos that there are deficiencies, but I think we need to reinforce this control parameter, which indirectly which is the presence of experts in certain areas, not just legal experts, but also economic experts, etc. For me, this is an aspect we can work on, and we have to improve this. There are other aspects, all the other aspects are also important, but this one has to be important. In order to be able to see whatever you want, you need to be free. In order to say whatever you want, you need to be free. If we have independent authorities or bodies defining general interest without other goals, they're going to be able to speak freely. So we need someone independent, because otherwise we have the situation we've seen created by different pieces of legislation, and we could debate on the consequences of being very critical within the state administration. We have several minutes ahead of us in case someone has any question. In the meanwhile, we have a question for Carlos. It's related to the third question, the third area we've covered, control. In the tender documents which offer benefits for a company, in the case, would this need to be subject to the CNMC? I think, Elena, you should also answer to this question. This is one of the areas which has been highly covered when preparing this piece of legislation. This created a true stimulus in the parliamentary phase. In my opinion, there was room for more. On a personal note, and leaving aside courts, especially in the region of Madrid, we focused on this phase. We hope that this can be reflected in other actions covering measures regarding competition, members of the body, any person who is involved in the procedure. I think your question basically refers to cases where a tender has certain criteria which can only be fulfilled by one company, or with solvency requirements which can be fulfilled by one country. Courts have resolved about this very often. Perhaps sometimes it wasn't a nice answer. The fact that there's just one answer, which is one company which is able to provide certain services, doesn't mean that there's a true restriction of competition, or this is a directed tender. And the European Commission has said this. What we need is a good preparation. When I'm drafting the contract, I have to say what I want and why I want it. I have to justify it. And as courts, when we see that there's a good justification, we don't mind that this is just one company. A different thing is where you have a completely artificial criteria. We have voided many tenders when they require a specific format or submission format which is indifferent. I want tubes with a certain color codes, and I want red Pantone 25. We don't care about this. We see that this is directed, it's targeted. It's not just corruption, sometimes it's just deficiency, it's a lack of progress, of innovation, and sometimes a little a little bit of corruption. But courts are dealing with this. But sometimes people don't like what we say, but we do analyze this. If we take a look to the cases, there's a list of best practices by the CNMC. They have a series of recommendations, and one of them was this: symbols. There's certain signs of possible collusions. For example, one offer, the different possibilities for corruption. But the CNMC provides a list of different signs for possible collusion. Semantic identity, semantic economic identity. The CNMC has said that in its guidelines for several years. There's another thing to be added: the balance between objective and transparent tendering and also innovation, because of course the one who innovates has the product, so we need to reach a balance between the two of them. Is there anyone in the room who wants to ask a question? I'd like to close this panel by summing up some ideas. First of all, what's lacking in the procedure and organization. We have insisted on the importance and efficiency of independent administrative control compared to the sluggishness of justice. And together with the professionalization, multidisciplinary teams have to be created, and also we need to look beyond the legislation. With regards to the second block, transparency, we acknowledge that something is changing, but we have also acknowledged that there's room for improvement and to intensify transparency. We have dealt with subcontractors and other things. And in this sense, we have insisted in the necessity of a cultural change. In terms of control, there are mechanisms, but we have insisted on the lack of implementation of efficiency controls, not just a control of compliance with the law. We have to go beyond this. And also accountability is important. Also covered the idea of diversifying control, involving agents in procurement procedure, and also moving to applying an automatic control and more preventive mechanism and less reactive mechanism. I would like to thank this conference for inviting me to moderate this panel. I would like to thank our panelists for their presentation. Thank you very much.